In the last video, we learned that the federal laws favor releasing defendants over holding them pre-trial. We've been talking about pre-trial bail, pre-trial holds, and pre-trial releases, right? Release or detain. These are pre-trial decisions that a magistrate has to make: release or detain. We talked about how there were three discussions, three sort of times when a court is encouraged to release a defendant, and then one when the magistrate is completely within his or her right and probably should detain a suspected criminal, right? Someone that has allegedly committed a federal crime. Okay, so in this video, we're going to go over what the three main options are to release a suspected criminal. And in the next video, we'll go into what are the options to detain a suspected criminal. Okay, the first one is going to be a release on personal recognizance. A lot of case law, a lot of state law will just call this ROR, released on recognizance. The language of this act, this particular act, calls it personal recognizance. So just note that if you're talking about this act, you want to use the verbatim language that the act uses. So they call it release on personal recognizance. Okay, that is in section B, right? So 1342B. It also, in that same section, it talks about an option for a unsecured bail, right? What it means to be unsecured is that it doesn't actually take any cash at that moment. So the defendant is not paying anything, which is one of the things that make it such a progress from the past, right? Where we took money from the defendant, the alleged person that has committed a crime who is innocent until proven guilty, right? We took their money. Now, in this very first option, and again, remember that we're going, as we go through these options, we're going from the least restrictive to the most restrictive. Okay, the least restrictive is to just release a defendant on their own recognizance, saying they promise that they will return to every court appointment that they have, right? They're going to come of their own free will. No one has to make them or force them. They're going to come. With the unsecured option, it is a promise, right? And it's being a promise, a legally binding promise. We have a contract, right? The defendant is going to sign a paper, and an example, that paper is going to be in the description below if you'd like to open it and you can take a look at it. It's going to basically state that the full amount of the bail, or whatever the magistrate is setting the bail at, if the defendant does not show up as promised, the defendant is promising to pay the amount, that amount listed in the unsecured box. So nothing is being paid at that time, but if they do not come to court when they're supposed to come to court, or go wherever it is that they're ordered to go at the time they're ordered to go there, they will have to turn over money. Or if it is sometimes, if it's actually a secured, so this is not an option here, but if it's secured, it's backed by property or some sort of asset of value, right? Generally in the unsecured, we're generally just talking cash. They would have to pay a cash amount specified in the box listed only if they do not show up, right? So option one of the three for release is just to release them and let them promise as a morally upstanding citizen that they will return, right? That they're going to return. They could be released on an unsecured bail amount, which is an amount paid only if they do not show up. That is option one. That is relatively straightforward. And of course, because we're going from the least restrictive to the most restrictive, it just makes sense that it's going to get more complicated as we progress, right? So option one is done. Option 2 is section 3, right? So 1342C. Now we're going to get into our conditional releases. If a magistrate doesn't feel that he or she can just let the defendant go and the defendant's own promise is going to matter, or that the unsecured amount is going to be paid and that will be enough incentive to get the defendant back. Now, moving to the more restrictive one, the magistrate is going to start considering different conditions, different conditional options that the magistrate can place on the defendant to try to further incentivize the defendant to return to court and to the appointments that are ordered by the magistrate. So in section C, we have 14 listed items, and we're going to go through each one. So again, it is in the description below, the act itself, if you would like to pull it up and follow along with me. But we're going to go through each of the 14 one by one. The first is they can remand the defendant to the custody of another person, ideally a law-abiding person, right? Typically, this is done a lot with teenagers or minors that have again, ideally law-abiding guardian or parent that can watch over them, that will say, and they will have to convince the court of, yes, I will be responsible for this person and I will ensure that they come to court when they're supposed to come to court or go to the appointments that they're ordered to go to. So that is, the defendant has to remain in the custody of someone who will be responsible for them. Okay, that is number one. Number two is that the court could require them to obtain or keep employment. The goal here is that if you're working at least a 40-hour job, ideally, that's going to be 40 hours less that a defendant has to go out and get into a bunch of trouble. So gainful employment, or any kind of something that is going to be rewarding to the defendant, is going to be beneficial to the community as a whole. Also, we don't want to put defendants in a position where we're not letting them work, or where we're taking away their livelihood, or where we're putting their family in jeopardy in any way, right? So employment is a good thing all around. So they could be required to get work if they're unemployed, or at least be searching, right? Kind of with similar requirements as if you would like unemployment, if you're collecting unemployment insurance and you have those regular requirements to search for work. Very similar things, right? To obtain or keep employment. So if you have a job, criminal defendant, don't quit your job. Keep your job. Okay? Conditions. They might have to start or continue education. Just like work, education is a very positive thing for the individual and the community. So when a defendant is actively engaged in education, likely they have less time to go out and commit further crimes. Education is always good. Ideally, when it's not forced, it's a little bit more enjoyable, but education, employment, and in the custody of another. Number 4, the magistrate could choose to limit the whereabouts of the defendant, either where the defendant lives, or just spends hangout time, or where they go to practice hobbies or skills. If those locations would interfere with the judicial process at all, you could limit those areas. Or maybe the defendant gets into trouble when they go to one particular place, like maybe a victim's house, or right, it could be the house of a significant other where they're constantly getting into domestic violence instances. The magistrate could choose to just forbid that location, or the particular locations where things tend to get a little bit illegal, right? That is option number 4. Option number 5 is to restrict contact with the victims and witnesses, anyone that could hurt the defendant's case, right? So no contact with victims, no contact with witnesses. Okay, so evidence. We want our evidence to stay intact. We don't want to let defendants go so that defendants can undermine our case. Okay, we want to keep our evidence. Number 6 is to report to an agency. This option is very similar to like a probation program where there's going to be some sort of federal program set up where the defendant can report and they can be looked at physically to be like, yes, you're still here. No, you haven't fled. You haven't left the country. You're still here. You're in one piece. So report to an agency is number 6. We're almost halfway through. Number 7 is a curfew. Yes, so teenagers are not the only ones that have legal curfews. So if it is made a condition, the thought behind this one is that a lot of crime happens at night. And if you do not allow defendants to go out at night, ideally this would limit or minimize the amount of harm that they're able to do. So a curfew is condition number 7 that a magistrate could impose. Remember again that we're kind of working from least restrictive to most restrictive, but this does vary from person to person, right? If you have a nighttime job, giving someone a curfew where they have to be at home is going to be really restrictive. So again, these are just things that a magistrate needs to consider. Okay, number 8, to restrict or forbid firearms or any sort of dangerous or lethal weapon. Especially if the person's committed a felony, keeping them away from weapons, or if they've committed a violent crime, is definitely seen as productive to society, right? We want to keep at least one person or the community safe. So keeping them away from firearms is definitely an option. But again, here the magistrate has to consider we don't want to limit anyone's constitutional rights, even if it's like a state constitution or state laws. If someone has the right to do something, we need to really consider before we take away that right. So right to forbid or limit firearms is number 8. Number 9. I personally don't think this one is a bad idea. I think a lot of people could benefit from this. But limiting alcohol use or drug use without a prescription. There are a lot of incidents that occur due to drinking and drug use. So if that tends to be a problematic area for the defendant, simply, I'm sure it's not simple, but making it a condition of release that the defendant is not allowed to drink to excess or to use any kind of drugs without being under the prescription of a medical professional could be a way to help that defendant, right? So not only are we concerned about the one person they may harm or the community, but we care about the defendant as well. Yes, we wish they would stop allegedly committing crimes, but we do care about the defendants. Okay, so that was number 9. Number 10, so one step more restrictive than saying don't drink to excess and don't use non-prescription drugs is to say if addiction is the problem and it's not the occasional binge or the occasional overdoing, is to say if it's an addiction, possibly a condition could be that you need to go to rehab, or you need to get counseling for that addiction, or you need to be in some kind of inpatient treatment facility. But we want them to get treatment, again, because we care about the defendant. And when we care about the defendant, we're also, in a way, protecting that at least one person that they could harm and the community in general. So we do encourage addiction treatments if that's the case. And that was number 10. So we're moving along. Number 11 is forfeiture of property or money. And this is going to be by means of a contract. Right? So anything we do legally, we know we want a contract. If you have not taken contract laws, which is one of my favorite subjects to talk about, you'll know that you don't have to have a promise in writing for it to be legally binding or for it to be a contract. The moment the elements of a contract are met, which I'm so sad we won't go over here, but the second you have that handshake in whatever form it takes, you have a contract. So the court does make the defendant sign an actual contract stating that they will have a forfeiture of property or money as a condition if they do not do what they're required to do. So this is often more closer to a secured bail type of thing than it is anything else. So, right, we're securing our promise with property or money. Okay, number 12 is to get a bail bond. If the court decides that none of the above 11 are suitable for that particular defendant, right, on a case-by-case basis, that particular defendant, the court could have a condition that a bail bond is necessary. Now a bond is generally only needed if the defendant cannot afford the entire amount of bail, which if bail is $100,000, $200,000, a defendant might not. Like, I couldn't do that. So in that instance, as we discussed in a prior video, they would likely use a private bail bond for a company or for-profit company to help them secure that entire amount. Okay, so notice how in the first video in this series about bail, we talked about it was at one point a really common thing in a lot of defendants were just bail bond, bail bond, bail bond. That was just kind of the go-to. And now you can see that in our 3 options for release, the first one requires no bail at all, right? No bail. And if it is, nothing is paid at that moment, right? There's no actual exchange of cash. And even on the second item for release, the conditional release, it's almost all the way at the bottom of the list, right, to get a bail bond. So this really shows that that isn't the way we really do things anymore, right? Way down the list. It's number 12 of 14. So number 13 is to return to custody after work or school. So this would be where a defendant is released, but it is a limited release. So they are released to go to work, to go to school, to do whatever thing that they're doing that is beneficial to themselves and the community, and then they are not released. Like, then they go back into custody or wherever it was that they were. So wherever it is that they were being held, they would go back there. And number 14 is going to be basically, it's a catch-all. So anything else, so any other condition that a magistrate or the court can think of that would help that defendant as a condition to ensure the defendant will return and will not harm anyone else in the period when they're released, a judge or magistrate could consider. Okay, so note that is not an exhaustive list because you have number 14 that basically allows the magistrate discretion to impose a condition that he or she feels would be reasonable under the circumstance. Okay, so we've gone through number 1 of 3, which is release on personal recognizance or the unsecured dollar amount set by the court, right? And number 2, which is a conditional release. There are 14 enumerated conditions. The last one is the catch-all that says anything else the magistrate can think of that would be reasonable to ensure the defendant will not harm anyone and make it back to court when he or she is supposed to. The third, again, remember that we are still working from least restrictive to most restrictive. Number 1 was not restrictive at all. It was basically based on a promise. Number 2 was there was some kind of condition, right? We'll let you go on the condition that. Again, if you've ever studied contract law, which again, I love to talk about, you know that there are such things as conditional promises, right? And that the bail or the release is conditional in that we promise to let you go and you can stay out so long as you meet this condition, right? That can be revoked at any time the condition is not met, and the promise does not take full effect until the condition is met, right? So it is very important. Making a condition is not a way to just let the defendant go and let them do whatever they like, right? They're held to upholding that condition. Okay, if they violate the condition, they get brought right back, and that is where we're at with number 3. So number 3 talks about 3 different things, and one of those is what happens if a defendant violates a condition, right? They made a promise when they agreed to the condition. If they do not keep their promise, what happens is in number 3. So this is D. If you're following along in the Act, we're in 1342 and now we're in D. So those list of 14 was in C and now we're in D. D is somewhere right in between releasing them and detaining them. Right in between release and detain, and it's called a 10-day detention. Oftentimes we have someone that is either released or has never not been in custody, or at least not for this potential criminal act, and we either want to retain them for a little period and then release them, or we want to detain them for a small period and then maybe give them an immediate trial, or whatever happens next, but it's going to be limited, right? So we're not fully just releasing them and giving them a condition or making them make a promise, but we're not fully detaining them either. So this one is kind of right in between. Our 10-day detention. Okay, this can happen in one of 3 enumerated instances, right? And that's one of 3. Enumerated, one of 3. The first one is a revocation of a condition. A revocation of condition. So this is exactly what we were talking about. So let's say a defendant made the condition to obtain employment, and they've been released on the promise that they're going to obtain employment. And a period of time goes by and they have showed absolutely no effort in getting employment. And in fact, the court finds out that they were offered employment and they turned it down. And it was a completely reasonable job. It was within the defendant's skill set. There should have been no problems with the defendant taking it, but the defendant chose not to, right? Or a number of other situations that could occur, but the defendant breached the condition, okay? Did not uphold their end of the bargain. So what happens? The court can bring the defendant back in and for 10 days detain that defendant while the magistrate tries to figure out what to do next. So they can hold the defendant for up to 10 days if the defendant does not uphold the condition that the defendant promised to uphold. Okay, so 10 days. And then if they violate that condition, it is revoked, and that's why it's called the revocation of the condition, right? That's the title, the revocation of condition, meaning that the condition is going to be revoked and it is no longer an option, right? So if the defendant promises to obtain a job and does not obtain a job or does not try to satisfy his condition, it is taken off the table. It is not an option. The defendant gets brought back in, held for up to 10 days, and either new conditions are made or possibly the defendant is just detained, right? And that just kind of depends on the circumstance. Okay, remember again, least restrictive to most restrictive. Next is for a deportation. A deportation. If someone is an alien, right, so not a United States citizen here lawfully, if they're an alien and they're inside the United States already, so however they got here, maybe they were on a tourist visa and they overstayed their visa, we're talking deportation. So again, we're talking federal, right? So we're talking about coming into the United States, like as a nation. We're talking federal, so a federal deportation. If someone is facing deportation, they can be held for 10 days, right? They don't have to just be released. Like they may not have a permanent address here or a phone number, or they may not have a residence. Like it might be really hard to find them if we just let them go. So if someone is facing deportation, they can be held for up to 10 days. Okay, up to 10 days. The very last one under the 10-day detention section is going to be exclusion. Exclusion is different from deportation, so let's talk about it so that we are able to keep them straight. Deportation, again, is when someone is not a U.S. citizen, but they're in the United States. So they're in the geographical boundary of the country. Exclusion generally happens at the border, so maybe between the border of US and Mexico, right? At a border, maybe the border between US and Canada, but the person is not in the country. They're generally stopped right at the border or maybe immediately outside the border trying to get into the border. If this happens and we're trying to prevent the person, the illegal alien or the non-United States citizen person from getting in the country, we can hold them under the 10-day detention policy, right? We can hold them for up to 10 days while the magistrate tries to determine what the best way to handle that particular circumstance would be. Okay, so we've covered a lot in this video. We've talked about B, 1342B, which was the first method of release, And then we're going least restrictive to most restrictive. Next, we have conditional releases. We went over all 14 of the enumerated conditional releases, and then we talked about the 10-day detention. So those are the three different primary ways that a magistrate decides either release or detain, right? So we've now gone over all of the different options for release, right? And as you can see, there's a lot, and there's only one for release. So again, that shows us that the federal legislative body really favors releasing defendants, right? Bring them in, file charges, release them, and then bring them back repeatedly until their trial starts, and further and, kind of finish the process, but release them. What happens when none of the three methods we just talked about seem reasonable or fair under the circumstance and a defendant is detained? We will talk about detaining in the next video.